Scot Peterson trial concluded. Defense rested their case in chief after calling multiple people that were there, teachers and students and officers, to say what he did was fine, what he did was right. None of us knew where it was coming from. It was echoey. I don't know how many shots there were. I heard 2, I heard 3, I heard 4. So all of that to me is an indication that they are very comfortable with their defense. And their defense case in chief lined up with their cross-examination. It lined up with their opening statement, and it was fluid throughout the beginning, middle, and end of this case. And that is how a trial is supposed to line up if that's how you're setting it up for a lawyer. Now, what's interesting is Scot Peterson did not testify. And if you remember back to, I think it was our first Scot Peterson video, which in case you forgot or didn't watch it, we are going to watch it together here. His lawyer was asked about Scot Peterson testifying. And here's what he said.
It sounds to me like this is an opportunity for your client to take a stand and explain what happened. Is that something we can expect? There's always an opportunity for that. And I'm going to tell you this. 99% of the time, I keep my clients off the witness stand. Number one, anyone can be made to look like they're guilty, even when they're not. Okay, we know that. Prosecutors already bragged to me that he's a skilled cross-examiner, right? So if my client takes prosecutors already bragged to me he's a skilled cross-examiner, and he just said he's going to destroy... Sorry,
I just realized it's not up on the screen. So let's try this again. With this new setup, I actually have to click it 3 times instead of 1 time to present. So I'm going to go back, and it kind of feels like Inception because you're going to hear me talking as well. But he basically said 99% of the time, I keep my client off the stand. Prosecutor's a skilled cross-examiner. But this might be a case where we let him testify, basically. Or crucify one of the officers. So, you know, lawyers, they like to talk about how great they are at this stuff. So he was asked, is this guy going to testify? Seems like he would. He said, and he's explaining kind of his philosophy on when a criminal defendant testifies. Okay, so let's listen in on kind of his philosophy.
And it's because he has to. And I don't
back it up just a little
bit. Is that something we can expect?
There's always an opportunity for that. And I'm going to tell you this. 99% of the time, I keep my clients off the witness stand. Number one, anyone can be made to look like they're guilty, even when they're not. Okay, we know that. Prosecutors already bragged to me that he's a skilled cross-examiner, right? So if my client takes a stand, it's because he has to. And I don't think he has to. Now, he might want to. He may insist, Mark, I got to get up there. He's telling me that. He's telling me right now, Mark, they've got to hear from me. I got to get up there. But if he doesn't, I'm telling you right now, it's because I tell him, you don't have to. You don't.
Well, I'll let Peter from a few weeks ago answer this first, and then I'll jump in. That's interesting, right? Letting us behind the curtain a little bit. Attorney-client privilege information, maybe. I probably would not have gone this far. I probably would have just said, we'll see. But this makes for good TV, makes for a good interview. He's telling us his client wants to get on the stand again. I think this is all calculated for you to see and hear his client, for you as lay people, right? To hear his client wants to take the stand, wants to tell the jury he's not guilty, wants to explain to the jury what he's saying, that you're thinking, yes, that's what innocent people do. So he's taking the blame as the lawyer, saying if he doesn't take the stand, it's because I tell him not to. And this, folks, is literally exactly what he said in closing arguments. Don't hold me against my client. Don't hold it against my client because he didn't take the stand. So let's listen to again why he said his client wouldn't take the stand if in fact he ended up not taking the stand, which is what happened, because again, this was before the trial.
Full of a prosecutor, make you look guilty, number one. Number two, it's not going to be necessary. They will not be able to prove this case beyond the exclusion of every reasonable doubt that he did a criminal act. The guy ordered a code red. The guy did everything he could to protect those students with what he had. We'll be able to prove.
I mean, you can't let code red be said 17 times in a criminal case without thinking, all right, so that's what he said. He is not going to testify because there is no way the state proves this case beyond and to the exclusion of every reasonable doubt. And that's exactly what happened. And that's exactly what he said in closing arguments. So let's get to those closing arguments. First, it is the state. They start out by saying there is a contract. It is his job. That's what they have to focus on. It is his job to protect those kids. Overall, I think this was a good closing because they have the timeline set up. And she went through the timeline. I think the first close was good, I'll say. She went through the timeline and said, basically, here's what Nicholas Cruz was doing, the shooter, and here's what Scot Peterson was doing. So as the shooter did this, Peterson did this or didn't do this. And that, I think, is effective because we get to see step by step how his inaction potentially failed to stop / a cause of the damage. And again, I thought that was effective. Saying all the victims' names. The details are so sad as she went through them again. But she would make certain statements like, well, everyone knew it wasn't firecrackers eventually, and everyone knew it was in the 1200 building. And that's not how I remember the evidence coming out. And that's why that was one of the tough follows throughout the case. Now, I think some of the best evidence by the state is Peterson multiple times over the radio saying shots fired 1200 building, in 1200 building, near 1200 building, enough that I think a reasonable juror could believe that he knew the shots were coming from inside the 1200 building. And that is what the state has to put their hat on. Because he does say it with his own words. And as we've always said in this channel, that if you can use the defendant's words against them, that is the most effective way. However, later they literally play where he says 1200 building or 1300 building. And then she says he directed officers to completely miss the shooter, to not render aid, to stay 500 feet away. And in conjunction with what they say in second close, it basically is starting to seem like they feel like Scot Peterson intentionally wanted harm to come to these kids. Almost as if he was an accomplice to Nicholas Cruz, which I think is wild. Wild. And then when she gets to the jury instruction for culpable negligence, that's the part I want to play for you here from the state's closing. So let's listen to this together here.
I will now define, and this will be read from the court, what is meant by the term culpable negligence. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without conscious intent to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. For negligence to be called culpable,
it is more, and by the way, these are the victims' families. It is more than a failure to use reasonable care.
It must be gross and flagrant. The negligence must be committed with an utter disregard for the safety of others. Culpable negligence is conscious.
It has to be gross. It has to be with utter disregard of the safety of others. It cannot just be an accident. It cannot just be I messed up or I didn't do the right thing.
Doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. The course of conduct or the acts were retreating and then standing outside of that building when he knew that the trigger was being pulled and that children were dying. Because there is an or on this first element, some of you may find that it was willful. Some of you may find that it was by culpable negligence, or some of you may decide that it was the bottom one, failed to make reasonable effort. What you must all agree on is whether this first element is met. Now, it's our position that element number one, all of it applies, no matter which way you read it, because his actions were an obvious lack of effort and obvious failures. What evidence did the state bring you to prove this first element, that he willfully failed?
And this is the important part, right? Because again, while I said through the defense's case, I knew what they were arguing. I knew where they were going. I felt like it made sense. All the chaos, all the craziness, didn't know where it was coming from, didn't know what the noises were, how many shooters, where the shooter was. The state's case, I felt like I had a tough time following exactly what they were saying, besides he just did nothing. And if he would have done anything, like in the rebuttal, second close, he said, like, Nike, just do it. That was tougher for me to follow. Nicole asked, do you think him not testifying will hurt his case? No. I think they had enough of his statements, and his defense attorney read some of his statements in closing that I think they had enough without him testifying. And I think it could have potentially gone bad if he did testify. So I think exactly what Mark Eiglarsh said in the interview before the trial is what happened during trial. My N. Do you think the prosecution's... Oh, sorry. I'm going to save the Melly questions until the very end so we can kind of go back to Melly because I didn't see them come in during the video. So we'll do that at the end. How long do you think it will take to get a verdict? I think by tomorrow. We'll have a verdict in Peterson. Peter, if you had a client that insisted on giving evidence and you really didn't want them to, would you show them Alex Murdaugh's testimony? No. I would talk to them about a lot of the cases and how things goes, but I would not show them Murdaugh's testimony. No. John O'Rourke, I feel terrible for Scot Peterson and believe he was at the wrong place, the wrong time, but I believe he didn't act appropriately. He just froze and more lives were lost. I can't imagine being placed in that situation. Tough. And John, we are going to post, and I guess John Nizer, we should post now the poll for do people feel like Scot Peterson is guilty or not guilty as we kind of work through the closing arguments here. P-Op, I wouldn't want to be on the jury. I see both sides. I'll give you kind of more where I feel after we're done going through the closings. Tori, I was held up at gunpoint and I can say your mind stops thinking. I feel for Scot Peterson. I think there's no doubt about it. It was an incredibly difficult situation.
Well, we brought you the surveillance video so that you'd be able to see what he did and didn't do. We brought you the survivors, Marion, Kyle, and Anthony, to tell you their injuries, the protection that they needed, and the fact that they did not receive it from Scot Peterson. We brought you the officers to show you what providing care and services actually looks like, what reasonable efforts look like. And we finally... So
they brought all these cops to tell us this is what it's supposed to look like versus what Peterson did. That's how they're proving these elements.
We brought you the trainings and more specifically, the training materials that Scot Peterson himself was taught on active shooters. Because the state has proven that the defendant failed or omitted to provide the services necessary for those children's physical health, because the state has proven that he did not make reasonable efforts to protect those children, you can check off this first element. The second element. In doing so, Scot Peterson caused great bodily harm or permanent disability or permanent disfigurement. Right underneath that, it says, neglect of a child may be based on repeated conduct or a single incident or omission that resulted in or reasonably could have been expected to result in serious physical or mental injury or substantial risk of death to a child.
And this is where the defense and their closing argument put up Nicholas Cruz's picture again and painted him as the monster that he is. And that's really where their focus is. So the state has to kind of shift focus and explain how Peterson caused this, not just the shooter.
In doing so, Scot Peterson caused these injuries. Now, in almost all neglect cases, the act in question, the causation is an omission, meaning not doing something that you should have done, to allow something to happen that was already happening or even caused by another person. To use examples to explain the term cause in the sense of child neglect can be pretty helpful. So an omission or a failure can be the cause of somebody else's injuries. An example of that is an adult that is at a pool with a child that cannot swim. The adult sees that child moving closer to the edge of the pool. That child jumps into the pool and begins to drown. The adult stands there and does nothing. Another example that we often use is a teacher in a classroom with students. A teacher's aide begins to physically harm one of the students. The teacher stands there, watches, and does nothing.
So I don't know if I love her analogy about the adult, just a random adult, but the teacher and the teacher aide is absolutely one. That teacher aide is under the teacher's control in the teacher's room, classroom. I don't see how that's analogous to what we're talking about here. But those are the examples she's trying to give about how Scot Peterson caused these issues, not just the shooter.
In both of those examples, it's clear that the person in question did not directly cause the injury to the child that fell into the swimming pool or the child that's being beaten or injured by somebody else. However, it was their omission, their failure to act, that caused the child's additional injury or death. Causation is defined for you in these instructions as even just one single omission. In this case, we have omissions over several minutes. Every unanswered gunshot, another act of omission. And then the additional 40 minutes where no aid is rendered by the defendant. The timeline and the physical evidence of casings is the best evidence for this element of causation. How many shots did the defendant stand there to hear? Not the shots before he arrived. We know there was a total of over 135 shots that day. But for the defendant to specifically,
A little flippant about it. There was like so many shots that day. It's like, yeah, a lot of people were killed by those shots. But only the shots we care about are the defendant saying that he only heard a couple, which you don't even know how many he heard. That's the problem, is they can't even say what he heard. They just are saying they know what he said was a lie.
the 2 to 3 shots that killed Aaron Fikes that he radioed in and told us, the 6 shots fired on the 2nd floor, according to crime scene detective Suarez, the 61 shots fired on the 3rd floor, according to Detective Crespo. Scot Peterson stood outside the building for 70 gunshots, knowing that death or great bodily harm was happening inside that building. In addition, there's the prolonged pain and suffering for Anthony Borges specifically, who laid in his blood for 40 minutes until somebody finally rescued him. And let me remind you that the person that finally rescued Anthony Borges was Detective Danny Polo. Detective Danny Polo was the officer that testified with the face covering. I asked Detective Polo, did you hear?
By the way, that is the guy testifying in the Melly trial that we were just talking about, the gang expert. He was also on scene here. It's pretty legit guy.
The order to stay back 500 feet? He said, yes. I said, well, then why'd you go inside? He said, because we don't do that. That was dumb. Why would I do that? Those kids needed somebody inside, not 500 feet back. Because the state has proven that the defendant had the opportunity to act and did not, because his omissions were the cause, allowing the shooter to continue completely undisrupted, the state has proven the second element, and you can check off element number 2. Element number 3, Scot Peterson was a caregiver for the victims. The definition of caregiver is provided right underneath.
So this is something they've got to prove. That's a long shot to me.
Caregiver
If I was a
means
juror.
Parent, adult household member, or any other person responsible for a child's welfare. The courts have actually explained that the phrase any other person responsible for a child's welfare has, quote, plain and obvious meaning. So was the defendant, who was the school resource officer responsible for the welfare of those children, a caregiver on this day? Yes. His only assignment every day was the welfare of those kids. The fact that the defendant was responsible for the welfare of the children at MSD is obvious based on the plain meaning, but also based on the school resource officer contract, which you all have in evidence, which you'll be able to take back with you. And quoting from that contract, according to the contract, his duties were to be at school during regular hours, right alongside the teachers and the principals, to assist in the prevention of juvenile delinquency, teach kids about law enforcement, develop positive relationships, help victims of crimes, and most importantly, protect and secure the school. You heard from school resource officers Gloria Crespo, Sergeant Heinrich, Lieutenant Cardinelli, Officer Burton. They all told you that as part of their role on campus, they act similar to teachers in the fact that they conduct administrative searches, meaning they can go through a kid's backpack. Unlike other law enforcement officers who need to get a warrant or have to be able to articulate it, they can just do what the teacher.
I still, every time they explain this, do not understand how this makes him a caregiver for thousands of children in football fields worth of buildings and parking lots and what, like, that makes no, analogizing him to a teacher in a classroom. That would be like saying, I'm an adult right here. If I go 700 yards in that direction, I'm responsible for all the kids that fall in every pool going this direction because I'm an adult. Or if I'm a teacher, I'm a responsible and the caregiver for every kid in this school, whether they're in my classroom or not, whether I can even see them at the time. How impossible is that? I don't think Mark Eiglar talked about that in his closing, but that's something I would have said. They gave you 2 analogies. Let's compare those analogies to what Scot Peterson was dealing with. Now, he definitely talked about how big it was, how many rooms there were, how big square feet, how long it took SWAT to do it, how Scot Peterson couldn't have possibly gotten there even if he was running and things like that. But I would have just used that teacher analogy. I just got 1 classroom. That makes a lot more sense.
And the staff on campus do, and that they're there to protect the kids. Welfare of the children in all sense of the word. Now, I want to pause to point something out here.
The fact that he can investigate them for a fake ID and not arrest them, why does that make him a caregiver? I don't get that. The fact that he can search their backpack without a warrant, why does that make him a caregiver?
Scot Peterson was the only police officer on that day that was officially assigned, clearly delineated caregiver for the children at MSD. None of the other officers who arrived on scene had any caregiver obligation as it relates to the statute.
And so I'm going to pause it here because Tori said, Why aren't all the other staff members being charged and those who ran away? I know it's his job, but at a school, you never really think some mass shooting will happen. And then Miraculous Huff said, sorry if I missed it, but why didn't the state prosecute the security monitor who did keep important information from the cops? Right. The negligence, I think Medina was his name. I don't know. Mark talked about it in his closing. What was the guy's name? We'll go through it eventually, but yeah, why not that guy? And I think it's because it's just a tough situation and everybody made some mistakes that day, but one person was ultimately responsible for this. That's what the defense is arguing.
Their jobs, those other police officers.
But the
is not
state,
to look
by the way, your questions, the state knows the jury has those same exact questions.
over just one collective group of kids. They respond to calls, they're on the road, they're in a detective bureau. Scott Peterson was the only caregiver because his only job was to maintain the welfare of those kids. Because the state has proven through the school resource officer contract, through the school resource officer testimony, and the school administration testimony regarding the expectation of the defendant's role on campus, you can check off this third element. Finally, element number 4 is what we often refer to as an element that's not really in dispute. There will be a stipulation.
Right, so we don't have to play this part. This is where they get into the damages. And again, we all agree there were damages. It's just they don't agree that anything that Scott Peterson did or didn't do caused those damages. That's the difference. And I want to try to play a part where she now goes into kind of the end of her closing where she's like, here's the common theme. Peterson did nothing.
The calls. Well, if you remember, Miss Oakley told us, kids in class, Scott Peterson is the claim that Scott Peterson needed real-time intelligence from the radio. Scott Peterson was the real-time intelligence. Scott Peterson stood there. He didn't know exactly precisely which classroom to go in. I agree with that, but guess what? It wouldn't have mattered because if you recall, Lieutenant Cardinelli asked him, hey, my kid's in classroom 1, 2, 3, 4, where's that classroom? He had no idea. What would knowing the precise classroom have aided as far as entering into that building? All this talk about nobody patched the calls. Well, if you remember, Miss Oakley told us just 3 clicks of a mouse, and we asked her, could Scott Peterson have requested the patch? And she said, Scott Peterson could have requested the patch himself. You'll notice that there's a theme in all of the reasons as to why the defendant couldn't go in the building that day. The calls weren't patched. Who could have asked for the patch? Scott Peterson. He wasn't wearing his vest. Whose job was it to wear his vest? Scott Peterson's. But there was an echo. Whose job was it to step out from that hallway if there's an echo? Scott Peterson.
So I get the patching and the vest. I think those are good arguments. It's his fault that there's an echo.
But he was outgunned. Who was provided a rifle that he chose not to have on his person? Scott Peterson.
So now is it a duty for every school resource officer to carry their rifle around everywhere they go? I wouldn't have a problem with that. I just don't know. And are we changing duties now that this has happened? Because I've never seen him really walk around every day with a rifle.
And I'll make a note here. There is absolutely no evidence in the record that Scott Peterson believed he was under sniper fire. He never.
So again, I think this was a pretty good close. I do. All right, let's answer some questions, and then we're going to transition into the defense's closing. Alice or Alicia, this is sad. I'm not guilty. Who knows what we'd do in this situation? We're programmed for fight or flight. In my opinion, there's only one responsible. And this is kind of the entire chat. So far is over 80% think not guilty and under 20% think guilty. Rebecca, every situation with an active shooter, I imagine it is different. A lot of money in the morning quarterbacking over this deal. Yes. Mark Eiglarsh, the defense attorney, does talk about how much easier it is to Monday morning quarterback this. Elspeth, the jury is only 6. How does that work? I don't necessarily know what this means. This is not a murder case or death penalty case or life in prison case. It is a negligence, culpable negligence of a caregiver. So that's why there's only 6 in Florida. Did he know their names prior to the shooting? I would assume yes. They said he had a good relationship with them, but I don't know that for a fact. Kim, if he's a caregiver, then isn't the police department required to provide the required 25 children to one adult requirement and have provided many more officers to provide that care? Seems far reaching. I agree. If they really want to apply this across the board, somebody else was then negligent to only provide one caregiver for this whole school, right? Or is he a combination of caregiver with the teachers? That's the point, is a school resource officer was absolutely not contemplated when that caregiver definition and statute was written. That's a fact. And that's what the defense attorney's been arguing a lot throughout this trial. Thank you, Brad. All right. So the defense gets up and starts out by saying something doesn't make it so. And he goes into, again, everything we've already heard them throughout the case. How many shots, whether they were shots, firecrackers, fire alarm, multiple shooters, sniper, inside, outside, 700 yards, 1,200 building, 1,300 building, senior parking lot, football field, all the stuff that was reported about all the potential things that could have been happening in all the potential places that it could have been happening. He talks about, he compares and contrasts Scot Peterson, award-winning, great guy, resource officer of the year, and then the shooter. There was an interesting part where he says they agree that we're not here about the people that were injured on the first floor. Yet they still talk about what happened on the first floor before Scot Peterson ever showed up because they want your sympathy. And the prosecutor objects, the judge overrules it, and the prosecutor says that's an attack on the prosecution. I wanted to play it, but it's annoying because it's still going because we're on verdict watch. So I can't go back and hit the exact timestamps. That's just a thing. Usually once the video's over, it's easy for me to go back and hit timestamps immediately without having to jump around too much. But Scot Peterson looks over at the prosecutor and he's like, really? He literally audibly says, really? Like, I'm attacking the prosecution? No, you guys are going for sympathy. That's why you put their pictures up and you made so much of the case about what the shooter did, not what Scot Peterson did or didn't do. Again, he said, don't hold me against my client. The state objected multiple times during closing argument, and the vast majority of them were overruled, which it was appropriate during opening because that's a statement, not an argument. I think they tried a little too much in closings. He also said, hey, let me save you some time. We agree that if you know where the shots are coming from, you go in and you try to do something to stop them. But Scot Peterson did not know that, and that's been their theme of the case the entire time. He also made a good point that a lot of people testified they only heard a couple shots, 5 shots, 3 shots, 2 shots. Nobody said they heard all 135 or 40 shots. Yet that's what the perjury comes down to. There are a couple things I did want to show from the defense's closing. Like when he read the perjury stuff. Let's see if I can catch it here. He's pointing all around. All right, so the perjury stuff, no, but we can definitely get when he talks about the burden of proof, which I liked his explanation there. All right. So perjury. He reads the statements again. He reads the context. It's absolutely different than you would expect somebody being on the stand saying, yes, I heard 2 shots. It's information gathering. He's doing his best to give the information. Now, more on that in rebuttal about what the state argues happened during that statement. Because the defense says he just was telling him stuff. He was like thinking and talking. It wasn't like he nailed it down. Are you sure that's what you heard? Which I think it would be incredibly unfair to convict him of perjury based on these statements. Just me personally. That one is like everybody that's ever made a mistake in an interview with a police officer then should be convicted of perjury because that's what happened. Or not even a mistake, but that's what he knew at the time. Regardless, let's listen to what he talks about when talking about reasonable doubt. I kind of like this chart here in his explanation.
There's a 45-acre campus. Anywhere. He couldn't narrow it down. Samantha Oakley said she was residency. I was exposed in the building. Injured in there, and he being a officer, operated properly. The charging document.
Here we go.
Ludicrous. Now you're going to see the charging document and understand that when you have the options, that not guilty is the only way to go in this case. And what not guilty means is not proven. You didn't prove this case beyond and to the exclusion of every reasonable doubt. The burden of proof is on the state. And if you think, well, maybe he knew where the shots were coming from, or possibly, or probably, or it's highly likely. The only time you ever find anyone guilty is when they prove the case beyond and to the exclusion of every reasonable doubt. That's why I tell you that your decision is very easy. This is a 5-minute not guilty. You do not owe anybody, again, you take as long as you want, but you do not owe anybody any extra time in that room. You sit there and say, they never proved their case. Not guilty hopefully means that you believe he's innocent, but it also just means not proven.
I thought that was a really good explanation. It could mean he's innocent. It could be not proven. This is a 5-minute case. Now, that's not saying you have to take 5 minutes, but it shows how confident he is in his case and in his client.
Ladies and gentlemen, I conclude by telling you that this is the most difficult time because the prosecutor gets up here and he's going to tell you things. Just ask yourself what I would say in response and use your own common sense. Understand that sympathy plays no role. Understand this is a very easy decision. We're all counting on you to make a wise and legal decision. And I also want you to remember the victims. Just remember them. Understand that Nicholas Cruz is the one responsible and that we do not do justice for the victims by doing an injustice against Scot Peterson.
Yeah, that's the same. That's
Ladies
an
and gentlemen.
inappropriate remark, sir. Yeah, that request is granted. Ladies and gentlemen, I want you to completely disregard the last sentence that the attorney just said to you. Go ahead, sir, your final word.
I will conclude by telling you that the case is now in your hands. And every minute that this is open without a not guilty verdict is a miscarriage of justice. You know what the evidence is. You know.
So again, strong words by the defense attorney, a lot of confidence. In the closing, he also said, we don't have any burden at all. I almost didn't want to call all these witnesses, but I did because I thought it was important for you to hear what all of them had to say. But we do not have to prove anything. We don't have to prove how many shots there were. We don't have to prove whether there was an echo. We don't have to prove any of this stuff. The state has to prove that Scot Peterson knew where the shots were coming from and what he should have done with the information that he had, that they have to prove he had, that they can't prove he had. Then on rebuttal, the state comes back and they start out with the Nike, just do it, which I think kind of was their theme the whole time, just do something. And then he goes hard at Scot Peterson. He didn't care. He chose his life, priority of life, his over everyone's, those kids. And he showed the kids' pictures and even paused to say, Scot Peterson cared about his life over hers. The defense didn't even mention the elements of the case, but the state called witnesses to prove each and every element of this case. And then to get to the perjury, Scot Peterson lied under oath because he didn't do anything, even though he had a responsibility as a caregiver. He was telling people to go other places, telling people it could be in this building or the football field. He was relaying information, holding people back 500 feet or yards because he knew if they went in, then he would have to go in. That's an intentional crime, in my opinion, at this point. That's not negligence. If you know where the shooting is happening and that people are getting shot, and you're telling people who could help to go away on purpose because you know that, you are an accomplice. He should be being tried as an accomplice to murder, if the state really believes that's what the evidence shows. That's what he said. Or he didn't say the second part. He didn't say the second part. I'm saying that based on what he said. The state literally said he knew where it was, and he didn't not only not go in, but he didn't let anybody else go in because he knew he'd have to follow them in. And he didn't want to do that. So he said it's over here, distracting, sending them away, keeping them back. I mean, I'm sorry. I don't know Scot Peterson. I don't know any of the people involved here in this courtroom. Maybe he screwed up. Maybe he was negligent. That's what's before the jury. I'd be willing to bet anything he didn't do anything purposely to hurt these kids or these students. And that to me is brutal by the state. The prosecutor also said, I thought about doing something dramatic and sitting here for 4 minutes and 15 seconds in silence, so you know how long that is. He talks about how caregivers and SROs have power and responsibility, and with that comes duty. Prosecuting police officers is not fun. And then he gets real low and starts to whisper at the end of his closing. And again, it's embarrassing when you're the second lawyer to do it. You don't want to copy the other lawyer. Like Mark Eiglar says, it's a 5-minute not guilty. And he says, this case is a slam dunk. You know he didn't do anything. Jury is leaving for the day and coming back at 9 a.m. tomorrow, SMM said. I would expect a verdict tomorrow. That was kind of my guess earlier. So, and somebody said no DP for Cruz was a joke. Okay, but I don't think that this fixes that. Right? My opinion. I don't think that this fixes that. Dog Life. Do you think the judge was trying to curry favor with the family by criticizing the defense's closing argument? I've never seen that before. I must not have caught that. Somebody else said the defense attorney was wasting their time. I have no idea. I think the judge has not been overly complimentary or kind to the defense attorney in the courtroom. But I think when the jury was out and we talked about that JOA, he kind of let us think what he really felt about the case. And I don't think the judge thinks that we should be here at all, personally. Defense requested the judge asking them to stay late. Judge said no. And again, defense attorney wanted the not guilty tonight. He wanted it to be reasonably, quick, I'm sure. But this happens sometimes and doesn't necessarily mean one thing or the other. The quicker it comes back, it could be a not guilty, it could be a guilty. So I think every case is really different. Okay, so that's all we've got for Scot Peterson. We will get a verdict tomorrow, I think. If not, I'm pretty confident we will get one this week. At this point, I am confidently in the not guilty camp. I do not think we should have even been here. I think this is a really tough case. It's a brutal situation, a horrible situation. I feel so horrible for the victims. I think a monster committed these acts and admitted to it. I think catching Scot Peterson in this net is really, really tough. And if it does happen, in order to apply this fairly across the board, I think some things need to happen. Belinda, I love his attitude. It's so dismissive of these ridiculous charges, which should have never been brought, in my humble opinion. It's just sad for everyone involved. People feel like he's being dismissive to the defense attorney, to the prosecutors. I mean, they kind of feel like it both ways. So I don't know. Outstandishing. Peter, why couldn't the defense attorney saying convicting Scot Peterson would do a disservice to the victim? I think he could have said that, but he would have said an injustice to the victim would be convicting him. Because I think that he's saying if the state proved their case, it's still an injustice, and the judge felt like that was an improper argument. I disagree. I think they could have said it. Okay. I'm going to go back and answer a couple Melly questions now. Belinda, whether he's in a gang or not, what difference does it make? He's either a murderer or he's not. Is it really a moot point? No. See, I think that it can be part of context, but I agree with you overall. It definitely doesn't prove the crimes. Miraculous Huff. Do you think the defense objecting to the mask on the expert appeals to the jury, especially the one who had issues with the mask as well? The additional objection today about the mask was outside the presence of the jury. So I don't think it had any effect on the jury at all because they probably didn't know it happened. David, question. Also with the evidence provided from prosecution, wouldn't the fight with NBA Youngboy play a factor into the shooting? It could, but I think that that's something that we have to see developed, right? I don't want to in this case because I don't really know a lot about it in the background besides what's come out in court. I don't want to put anything extra in here. I'm trying to go off just what's happening. And him reading all those texts today didn't do a lot for me except to think maybe he is associated with this gang or these gang members. Kimmy, question. Now that the trial ended, I think this is back to Scot Peterson. Do you still not think the state's application of caregiver standard might be open the door to teachers, faculty if they don't follow procedure in the future? Yes, I do. It's exactly what I meant by the end. I think this could change the way we look at a lot of things for perjury and caregivers. And probably not the way the people that wrote the laws intended. Alicia, do you think if they find him guilty, there's a slope towards holding people responsible for their gut? I get training, but this isn't it. You're all getting it at this point. Slippery slope type of an argument here. Juror number 3, Tori, I don't know what this means. Is this about the juror that was dismissed and then they brought in an alternate. I'm not sure. I need more context about it. Like I said, I was following both the trials today. It was kind of miserable on in the background. So it's very, very possible I missed something. Thank you, Azam. I am going to take off, but I am going to record something tonight on the Koberger, the state's notice of intent to seek a death penalty. So keep an eye out for that. Hit the subscribe button, hit the reminder bell so that you can be there when it drops. And please hit the like button so that anybody that wants to see it can go out on their algorithm. So how did juror number 3 not get on the, or even get on the jury? I can't remember what it was. Oh, she was like a victim's advocate or something. I think that's what it is. I don't have enough info to really dive into it for you guys. So I apologize for that. But I've got to take off. More coming later. Thanks for joining me. I will check you and catch you on the next side. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.